Welcome to FOXSOUL's Black Report with our continued coverage of the justice for George Floyd, the trial of Derek Chauvin. I'm Romeo.
Hey there, I'm Brooke.
I'm Demi. And I'm Melissa.
On today's report, a drive-by shooter targets the National Guard in Minnesota. Minneapolis public schools plan to close ahead of the Chauvin trial final verdict, and Facebook ramps up content moderation.
We talk consent decrees, criminal justice reform, and get you on the ground in Minneapolis with civil rights attorney Nakima Levy-Armstrong.
And civil rights attorney Sue Ann Robinson is here to discuss today's closing arguments.
Soulmates, we have all of that and so much more. So if you're ready, it's our voice and our truth. Let's get it.
To me, this reeks of conflict of interest.
Do we know if he actually waved a gun? We only hear one side of the story.
This just really did make me feel good that the justice system did what they needed to.
We're going to keep following this story, and we will have the latest for you. Derek Chauvin's fate is now in the jury's hands. We saw closing arguments from the prosecution and the defense Monday, wrapping up a 3-week trial. The jury is now deliberating, and we wait. Former Minneapolis police officer Derek Chauvin is charged with murder and manslaughter in the death of George Floyd. Floyd died after Chauvin held his knee on Floyd's neck for more than 9 minutes. The jury will have to decide whether Chauvin's actions played a significant role in Floyd's death. Here's a demographic breakdown of the 12 jurors. All right, 2 white men, one in his 20s, one in his 30s, 4 white women, 3 in their 50s and 1 in her 40s, 2 mixed race women, 1 in her 20s and the other in her 40s, 3 black men, 2 in their 30s and 1 in his 40s, and 1 black woman in her 60s. Chauvin's full charges are 2nd-degree unintentional murder, 3rd-degree murder, and 2nd-degree manslaughter.
Joining us now to discuss today's closing arguments is civil rights attorney Sue Ann Robinson. Sue Ann, welcome back to the show. It's a pleasure having you. How are you doing today?
Doing pretty good. We're all on verdict watch.
Yes, we have questions, but we'll get to those. But right now, let's just take a listen to some of the prosecutor's closing arguments. Take a look.
It is not an excuse for the shocking abuse that you saw with your own eyes, and you can believe your own eyes. This case is exactly what you thought when you saw it first, when you saw that video. It is exactly that. You can believe your eyes. It's exactly what you believed. It's exactly what you saw with your eyes. It's exactly what you knew. It's what you felt in your gut. It's what you now know in your heart. This wasn't policing. This was murder. The defendant is guilty of all 3 counts. All of them. And there's no excuse.
Okay, Sue Ann, what are your thoughts on that?
I think it was important for the prosecution to argue with that righteous indignation, that absolute disgust in their closing argument that they use so many times when they're arguing to convict Black and brown people. So I was glad to see the prosecution kind of get emotional and really just give the jury the facts, but also give it with some emotion. I think they did a good job. I think it was important that in their closing argument, they explained to the jury that use of force is to respond to a threat, not a risk. And the defense spent a lot of time discussing the fact that Chauvin was responding to prospective threats, the shouts from the bystanders, the issue that George Floyd's size. These are all things that present risks. But in terms of actual threats on Chauvin, there were none. So I thought it was masterful that in the closing argument, the prosecution weaved in the fact that the actual use of force policy says that the use of force is to be used for threats, not for the risk of threat.
So let's take a look at some of the defense attorney's closing arguments.
When you review the entirety of the evidence, when you review the law as written, and you conclude it all within a thorough, honest analysis, the state has failed to prove its case beyond a reasonable doubt. And therefore, Mr. Chauvin should be found not guilty of all counts. Thank you.
All right, Sue, and what do you think? Did the defense do a good job of planting any doubt in the state's case?
They planted something. I mean, Eric Nelson was kind of throwing anything out there. His closing argument was like putting raisins in potato salad. He was just kind of like, what else can I throw in there? What else can I say? It's hypertension. It's diabetes. It's a 9-year-old girl in a love t-shirt. It's carbon monoxide. It's the pavement. It's snowing. It's Wednesday. It's Valentine's Day. He had Lucky Charms this morning. Like, he was like, let me just say anything. And the problem is when you go into a closing argument with a raisins in the potato salad style argument, it doesn't come together. It never comes together. And the purpose of a closing argument is to bring all the evidence that's been entered in through your witnesses together for the jury to take into deliberations. And he just didn't do it.
Sue Ann, Jerry Blackwell, the prosecution named the 46th witness Common Sense. Take a look.
I'm going to start talking to you about what I call the 46th witness. You actually have heard from 45 witnesses on the stand, but there is a 46th witness. And this witness was testifying to you before you got here to the courtroom. They testified over everybody else's testimony on the stand. It's the only witness that will be talking to you when you're back in deliberation. And that witness, ladies and gentlemen, is common sense. Common sense.
So the prosecution basically got 2 bites from the proverbial apple here. They get to, start their closing arguments, and then they get to do a rebuttal against the defense's closing arguments. What did you think about Jerry Blackwell's rebuttal?
Jerry Blackwell was everything in rebuttal close. Mm-hmm. I mean, Jerry Blackwell definitely did the rebuttal. He did a trial lawyer's rebuttal close because he listened to all the arguments and all the comments made by the defense, and he balled it up into a bow and he threw it right back in the defense's face. When he said his very last line, when he said, oh, the defense is trying to convince you that George Floyd died because his heart was too big, but he actually died because Derek Chauvin's heart was too small. Mm-hmm. I stood up. I was like, period. Thank you, Jerry Blackwell. Exactly. Because Derek Chauvin is a heartless man hiding behind a badge. And that's really what it came down to, because all the witnesses on prosecution side, the police witnesses, the experts, everybody said, there's nothing reasonable about what we're watching. There's nothing reasonable. Derek Chauvin had to be tapped on the shoulder by a paramedic after George Floyd had already been unresponsive with no pulse. He still didn't get up. Somebody had to tap him to say, hey, take your knee off this guy's neck. So him tying it up and saying, listen, he's saying because his heart was too big and it's really because Buddy's heart is too small, period.
Steve Sletcher and Jerry Blackwell both have been doing an absolute amazing job, the entire prosecution team. Sue Ann, so happy to have you back. But on the other hand, Nelson's closing remarks, as you could tell, 2 hours and 30 minutes or more. Some pool reporters were noted, and jurors said that they were getting antsy, and the judge even had to interrupt Nelson to call for a lunch break. In your experience, typically how long are closing arguments?
Closing arguments to me is a time to be punchy because the jury already has all the evidence. So it's your time to give them the highlights, tell them the inferences that they can argue from the evidence that's already been introduced. So I feel like Eric Nelson spent a lot of time just trying to give theories, giving horrible food analogies. This is a pensive time. This is an important case. All the cases are important, but obviously this is a very serious case, not just in that courtroom, but for America. So to me, for him to be using a cookie recipe to explain to the jury the elements, I just think that his closing had a lot of parts to it that were not necessary. That's why I said, it's like he's putting extra things into the food that's not needed. He could have gotten away with, explaining his evidence and saying that it's tragic that this occurred, that his client who didn't testify, who doesn't have to testify, has some sort of remorse, obviously, for the end result, and sat down. He insisted on going head to head with Tobin, who was the star witness for the prosecution, really a top tier heart doctor, and insisting on doing that. It's like, sir, it didn't work on cross-examination. It's not going to work now. Now's not the time for you to try to rehabilitate your case. It's the time for you to argue the things that aren't evidence and sit down. And I think he did more damage, honestly, in a lot of the different parts of the closing than he did good for his client. I saw that Chauvin came out of his mask today to kind of give the jury, another view of his face, other than what we've seen in the video, which was interesting. And trial is theater. So it is important for them to do things like that. But I definitely don't think Eric Nelson was giving the closing argument the weight that the case warrants, the type of pensive and discussing a tragedy and saying, yes, my client was there, but this is a tragedy. I don't think he did that.
Civil rights attorney Sue Ann Robinson joined us throughout the trial. We really appreciate that. So defense attorney Eric Nelson raised a motion for dismissal after closing arguments because of jurors not to be sequestered during the trial, the media attention, and TV shows. Was he throwing like a Hail Mary at that point, or does he have a legitimate concern?
I mean, his legitimate concern was his case, okay? And he was like, what can I do? Motion for acquittal is a standard motion, but I think throwing out that the media and all those things, it's like, that is your case. That is your case. The jury's been instructed. You needed to construct an argument and construct a case to deal with that. And if he didn't do it, saying it at the end of the trial isn't something that's going to help now. So absolutely, I think the Hail Mary analogy is perfect.
Okay.
So also in that mistrial motion, the defense attorney mentioned Congresswoman Maxine Waters, right? At a protest recently, she said protesters should get more active and confrontational if Chauvin is not convicted. In Nelson's motion, he claimed she incited violence. And just for our soulmates, I want to be clear, she did not threaten violence. But again, the judge denied the dismissal, but called it abhorrent that elected officials won't stop talking about the case, and also told Nelson that Waters may have given him something on appeal. I'm curious your thoughts. Do you think the Congresswoman's comments have affected this case in any way?
Listen, people are big mad, okay? And the issue is George Floyd's case, Derek Chauvin killing George Floyd on camera, 9 minutes and 29 seconds is a flashpoint for the entire country, for the world, internationally. There's nothing that the judge, Eric Nelson, anyone can do about that. Maxine Waters saying, listen, we have to stand up for ourselves. We cannot allow ourselves to be killed. We have to support these families. We need police reform, and we need to fight for it in the streets in terms of protesting actively and doing the things that we need to do civically to get things done so that change can happen. I don't see how that's an issue. I just think that, Eric Nelson and possibly the judge is feeling out of sorts with the attention that the case is getting. Because to be honest with you, 5 years ago, even 10 years ago, remember that the Trayvon case receiving the amount of attention that it did was new. For a case that happened here with police excessive force to receive, police excessive force like case to receive that international attention was something that's new. I think at this point, it's like, get into it. We are fighting this beast as a people. We are fighting this beast as a country. Reform is coming, and just deal with it.
So, Ann, I think you're absolutely right when you say that between his motions, Eric Nelson, between his motions and his closing arguments, he was basically throwing spaghetti at the wall just to see what sticks. We also noticed today in court that Minnesota Attorney General Keith Ellison was in the courtroom today. What type of message do you think that sent to the jurors?
I think that the Attorney General being there shows the jurors that this is about justice. This is about, the Attorney General is watching. We're all watching. We all want to make sure that what needs to be heard, seen, understood, that's happening. The Attorney General was present throughout the trial, even last week, interacting with the family and stuff like that. So I think it just overall, everyone understands that, you know, we can believe our eyes. We can believe what we saw, and what we saw is murder. Obviously, the attorney general isn't going to take any particular side in front of the jury, but I definitely think, you know, just his presence says to everyone, we're going to take these kinds of cases serious. And, you know, again, the flashpoint of the case is Black Lives Matter. And I think him being present for the trial says a sentence to that.
What were your thoughts on the judge's jury instructions?
Listen, I strongly believe and have said from the beginning that the devil is always in the jury instructions. The definitions of reasonable, the different definitions for reasonable doubt, even how the jury interprets the instructions and applies it to the evidence that they've received is going to be what they're doing in deliberation. So I've seen some of the motions and read through some of the motions about the definitions that the prosecution wanted, that the defense wanted, and even just the standard jury instructions. And again, I think it's very easy to see, based on the state's most compelling piece of evidence, what happened in this case. I think the hurdle is going to be intellectually to put it into the second degree charge because of the assault that has to be proven in order to have the felony murder. That's going to be something, because that's not something that, you know, we're accustomed to doing. So that's going to be a jump intellectually, but I'm sure the jury can handle it. They've been there this entire time. They've watched the evidence. They've seen the video. So I think, you know, they have something to deliberate. And certainly the prosecution gave them how many witnesses? 46 witnesses to think about.
Sue-Ann, I have a question. Eric Nelson showed different body camera footage during his closing. And so an obvious question is, how in the world would he think that is helpful? Why would he want that to be something coming from him that the jury saw last? The video is obviously why we're here. You know, why do you think he did that? Do you think he thought, you know, the prosecution is likely going to do it, so let me get ahead of it? I'm curious, why do you think he showed the videos?
It's very risky to use the prosecution's most compelling piece of evidence in the case during your closing. He would have had to come with the most swagged out, drippiest closing in order to bring in the prosecution's most compelling piece of evidence. Honestly, just based on how he was speaking, I feel like he's out of touch with everyone else's perception of the video and what happened. Otherwise, it makes no sense. I would never introduce the prosecution's most compelling piece of evidence unless his idea has always been to paint some bigger picture theory. Like, oh, yes, you guys are talking about 9 minutes and 29 seconds, but it's about 16 minutes. And it's like, no, it's not. The charges are based on those 9 minutes. That's when the murder occurred. So trying to paint a different environment by introducing the video was very risky. And I think I honestly, I couldn't watch the video anymore. So I can't even say at this point how the jury felt. I'm sure they were, you know, worn out emotionally from watching the video. And then Eric Nelson further insulting the jury by telling them, what did he say? Oh, let's be intellectually honest. What? Like, okay, sure, let's be intellectually honest. Why does Derek Chauvin have to be tapped by a paramedic to take his knee off of someone's neck who has no pulse and is unresponsive? Let's be intellectually honest about that. You know, I just think the closings for Derek didn't go well. Maybe he's doing it so that he can have some counsel issues on appeal. Who knows? But I can say one thing, that this definitely is going to be a flashpoint for our country. I'm definitely keeping Minnesota and all the citizens there in my prayers, and certainly the George Floyd's family.
That is so true. Sue-Ann, we have so many questions, just not enough time, but thank you. And we send prayers to Minneapolis as well. We'll talk to you soon, okay?
Okay. Bye, soulmate.
Take care.
Bye, Sue-Ann.